I mentioned earlier that there's a change of program, so Dayne O'Meara is going to talk to us about what we can actually learn from genealogies. Dayne's now working in Victoria but has come to Victoria from the NLC. So over to you. Thanks, Dayne.
Thanks, Julie. Now, give me a moment. I'll just turn my computer back on. Am I all good? Sonia, is it coming through? Yeah, just a sec. All right. All good there. Okay. I'll just shift this so I can see my notes. This will work. Okay. Hello, everyone. Thank you for having me. For those I haven't met before, I'm Dayne. Yes, as Julie said, I've been working in the Northern Territory for the Northern Land Council for several years. And I just recently moved to Victoria. I'm working with Wurundjeri now here in Melbourne. I've worked with a lot of genealogical material in my time, although there's plenty of people here who are more qualified than me, so feel free to chime in later on when I give you a chance. I've worked on compiling evidence for land claims and native title claims in the Northern Territory. I've started working on native title claim stuff here in Victoria. The majority of my work experience in the Territory, though, to be honest, has been in the post-claim environment, the ongoing administration of land rights, statutory land rights and native title rights in the Northern Territory. And so part of my talk is a bit about that side of things as well, which I think will complement well the focus on the court processes that we've had so far today. And I do have the honour of being the first anthropologist presenting today, so thank you all for letting me do that. Now, before we go further, can I just have a quick show of hands? How many people in the room are anthropologists? Okay, and how many lawyers are in the room? All right, good, we've got a good mix. I was worried there'd be like two lawyers came or something, and this is all for nothing. Thank you all for coming. Now, I wanted to start with just a little quick activity for us, just for a couple of minutes. Now, I'm going to circle back to this question at the end and give some of the anthros a chance to answer it. But particularly for the benefit of the lawyers, I thought I would ask you, regardless of what you know about genealogies, have a go at quickly sketching one, just as an example, just for a couple of minutes. Don't do it, make it a big complicated thing. And it can be your genealogy, it can be someone you know, you can make it up, it can be from a movie, family or something. Just have a crack at it and see how you do it. With no guidance, I'm not going to tell you how to do it. If you've ever seen one, you can model off of that, or you can make up how you want to do it yourself. I'm just curious what people come up with. So I'll give you just a minute just to quickly sketch something on your notebook, and then I'll ask you a couple of questions about how you've gone about that. I might just float around the room really quickly to have a peek over your shoulders so I can comment on them a bit. All right, I'm going to stop it there. I don't want us to drag on too long. Now, I'm curious about what information people included and what information they didn't include, and obviously how you portrayed that information. Now, There's a lot of different ways you can draw genealogies to represent the relationships of family and kinship between people. Some of you might be familiar with this kind of symbology, which is what we use at the NLC most of the time. In anthropology, we tend to use triangles for men and circles for women, and we have lines for deceased people and ways of representing marriage, and this kind of thing is all pretty standardized, but it varies a lot depending on what software people use and whether something's drawn by hand or whether it's on a computer and that sort of thing. Some programs use little boxes, some programs have just names. There's a whole different set of ways of doing it. So don't feel bad if you've done it some different way. I've noticed a few people drawing little squares, some people wrote names, some people use these symbols in what they've drawn on their page. Now, in terms of what information you include or don't include, now, in the very short exercise I just gave you, there wasn't time to include too much. So most people have focused on linking people together as siblings, parents, spouses, that kind of thing. Some people have written some names, it looks like. Now, what's not on those genealogies is a lot of stuff that does usually go into genealogies that are used for native title, that I'm going to talk to a bit today. Just sort of the broader context that can be brought out through using genealogies. Now, I've just put up a couple of examples of like what genes might look like. This is just showing some of the shorthand terminology we use in anthropology to map different relationships. And you can sort of impose, kinship terms of a particular language on top of this kind of thing. In the Northern Territory, we have a lot of patrilineal systems that require specifying different relationships to a patriline, and so we have colour coding kind of systems. This is a huge one, just to show you the complexity that can arise. This is a fictional genealogy from Game of Thrones, so don't look too closely at it if you don't want spoilers. That's House Targaryen, for anyone interested. You can't really read it anyway, it's that big. Now, the point of all this is that native title claim genealogies, I'm sure a lot of lawyers, the first thing in their mind is that it shows descent. That's what you really most critically need it for a lot of the time, is you're showing the relationship to the apical ancestors of your claimant group to prove that the present day claimants are descended from those people at effective sovereignty. There are a lot of other things that genealogies can show that are directly relevant to native title claims and the cases that the lawyers need to put together. So failing to get that expert evidence from your anthropologist is a bit of an oversight potentially if you haven't considered that. Now, I'm going to run through some of these points I'm going to put up in more detail, but a lot of them are just flagged here for you to see, and some of them are more obvious than others. So evidence of descent from ancestors, you've got principles of filiation and how you get recruited to a group, marriage systems, moiety systems, relationships with other groups, how the structure of the group changes over time, kinship structures removed from land tenure specifically, naming practices, and particularly where there's alternative names that might be in use in different contexts, connection to specific places. You might have birthplaces, you might have indications of where that person has ties to, and rules about adoption or other forms of recruitment to a group that are not biological in nature. So this is a pretty long list of stuff that is beyond descent purely, that is directly relevant, I believe, to making the case for native title a lot of the time, and choosing which bits of that go onto your genealogy and which bits don't might be something that I suppose lawyers may have input into about what questions they want their anthropologist to focus on in preparing that genealogical evidence. And it also suggests the importance of having an anthropologist involved in preparing that genealogical data and evidence, because I think it's a form of evidence that it can be tempting to think, well, this is all just factual material that I can get from births, deaths and marriages. I can compile a bunch of marriage certificates, birth certificates, and construct a genealogy based on that. It's very factual, very objective. I put it before a judge and I say, look, this is the line of descent, done and dusted. There is inherent value in the methodological process that an anthropologist goes through in collecting and compiling a genealogy using that method, but also combining that with oral history and talking to people and eliciting some of those broader contexts that get tied into that genealogy. And those are things that are more difficult for a lawyer to do because they require training in our methodologies and expertise in understanding that material and bringing that all together. Now, my first example that I'm going to give today is nothing to do with native title, and I'm doing that deliberately because I feel like that will be good for lawyers to see a little more about broader anthropological methodology and how that sort of brings us to the process we use in native title. So I'm going to show a little short clip from my PhD fieldwork in Thailand, where I'm talking about I'm reflecting on my field notes. And there's a little bit about genealogies at the end, and then I'm going to talk through a genealogy that I collected in the field. Now, Sonia, are we able to... Do you want me to play it here, or did we get that working? Okay.
Exactly how many households here are Buddhist as opposed to Catholic? My notes can't tell you, even though I sometimes feel like they should. What my notes capture more than anything else are relationships. Personalities. Insecurities. Social cliques. And spots to hang out. The shift of seasons in the schoolyard. From checkers through to marbles as the latest craze. My notes chart a map.
มันจะมีห้อยๆตรงนั้นที่มันจะมีทาง
ครับ
แล้วลงมาขึ้นมาอย่างนี้ถึงเราจะเด็กอันนี้เสียแล้ว
เสร็จแล้วไหม
เขาเสียแล้ว
เสียอะไรนะ
อันนี้เสียแล้ว
เสียแล้วไม่ถึงว่าตายแล้วเนาะโอเคถ้าตายแล้ว
All right. Now, I finished that clip on a little genealogy exercise I was doing with someone. Obviously, I was working a lot with kids in Thailand. I was based at a school. Now, genealogies didn't form a major part of my methodology or my project. The purpose that I did use genealogies for in that context was really a rapport building exercise. It was just a nice little getting to know you activity with people. This girl in particular, I taught her how to draw genealogies using my system. And she really took to that. She was the most helpful 7-year-old I've ever met. She also drew that little map of the village you saw there as well. And the value for me in getting the genealogies from her was doing it as an iterative process. It was mapping where her knowledge and understanding of things sit with her rather than getting an objective view of the whole family she's connected to. And I've got here, oh, hang on if I skip to the next slide. There we go. There's 3 different iterations of the genealogy that I took from this little girl. And it demonstrates how this information has shifted over time and the different things that I learned from doing that process. So the first one at the top was the initial one that I drew, just talking her through it, and it was just a very small genealogy, just showing her aunts and uncles on her mum's side, just to show her what it means. Now, the next one we did is about a month later. We came back to the same page on my notebook. My field notes are very back and forth because the kids contributed directly to them quite a lot. I've added in about a month later another one that she drew herself, and that's the one that you saw in the video clip at the end there. She figured out the symbols and everything. And she thought herself, oh, this person's passed away. How do I represent that? You haven't taught me that yet. So, and then she asked me that, and she indicated that her grandparent had passed away. And she added a little more information that time. There's both sides of the family represented, and she just chose to do that time. And then another month after that, we have this much larger genealogy that she did completely on her own. I wasn't actually sitting with her when she did this. She just kind of scribbled it in my notebook when I wasn't looking. And I don't know how accurate it is to her actual family relationships. I don't know if she was making up some of it to fill in the gaps, or if she really knew that much of her family, because she's down the bottom here. And she's drawn up to her great-grandparents, and the siblings of her grandparents are on there. I don't know how accurate that is, but it's still useful data to me to show that that's how she was understanding how kinship works. And it taught me a lot about her understanding of where she fits in and how many people she's connected to potentially and that kind of thing. So that's why it was really useful to me, even though I wasn't interrogating the objective fact of her family relationships and I wasn't doing this in any systematic way. It was still a really valuable methodology in my general research. And that is kind of a quality of genealogical research that we do still bring to native title, even when we are taking a more focused approach on certain aspects of it. I also had difficulty getting clear and complete information from the kids when I was doing genealogies with them, and that in itself was relevant data. So there is value in having a sort of composite genealogy that you construct based on different data points to give a fuller picture, but you can alongside that have partial or incomplete genealogies that give you a snapshot of what one person or one group's understanding of a matter is. I think both of those approaches are valid in different contexts. And you see on the top of that note page there, I've written Tasenyaba, which means I don't know in Karen language, and because that's what the kids kept telling me when I kept asking them, oh, how many brothers does your dad have? How many sisters does your mum have? How many are your grandparents got other siblings or other cousins? And a lot of the time the kids, these are like 7, 8-year-old kids, they're just like, I don't know. I got that answer a lot, so I noted that on there. And so that brings me to sort of a more academic question underpinning genealogical research, is what is kinship? Because at the end of the day, that's kind of what genealogies are built from. It's part of kinship studies that anthropologists started using genealogies. Now, I've just put up here one possible definition of kinship. I'm not saying I necessarily adopt this definition, but it's a very broad definition of kinship. So it's a useful conversation starter. Marshall Sahlins describes it as mutuality of being, and he does so deliberately to put biological kinship down a step and suggest that it's just one possible way of reckoning family relationships and kinship. To look at, okay, even if in 90% of the case biological kinship is really paramount, why is that the case? And what is the sort of logic underpinning that? And that's what we try to get at as anthropologists in a more academic setting. And this obviously comes up to an extent in native title when we're dealing with systems of adoption or incorporating people into a descent group when they're not biological descendants. So in that sense, it does sort of come in. Now, what we are doing in preparing the evidence on those things, though, is we're rendering them legible to the court system and the administrators of certain legislation. And there's a lot more going on, I think, under the hood of how anthropological research is conducted and the kinds of material we collect in the field, as opposed to how that ends up being presented in a final connection report or expert report that's being used for some matter. Now, my little thing that I kind of try to hammer home to people whenever I can is that even if something isn't appropriate in the expert report or isn't going to end up in the courtroom, but it is part of the methodological process or the analytical process of the expert, it has really got long-term value to that matter, to retain that information, to document that information somewhere, even if it is not framed perfectly as expert evidence in terms of being presentable to a court. And I'd say that coming out of my context of working in a post-claim environment in the Land Council, where often I would be working with, for example, a genealogy that Jitendra made decades ago, and we're trying to distill what this information means or where it came from or what it was based on, and we have to make assumptions to direct where we go from there when new issues arise. It's very helpful to have access to people's notes or to be able to speak to the anthropologist that did earlier research to understand broader context than what is contained in the final output of that research. Now, I recently published an article about my work with the Northern Land Council about local dissent groups under the Land Rights Act. That's in the Australian Journal of Anthropology. And one of the things I talked about this issue in that article, and one of the earlier drafts of it, when I got some feedback, the feedback was that I was kind of suggesting that anthropologists do things that they already do. That kind of goes without saying. I was pushing for like, oh, you need to be considering all these broader things of the local politics and, you know, who has battles with mental health in the community, who has dealing with addiction, what are the little quarrels that are going on, what are all these other broader community aspects that are relevant to how the claimants present themselves and their evidence. And it's the sort of things that usually don't go into an expert report necessarily if it's not directly relevant to the questions. And the feedback I got on this point was basically, oh, but we already do that. We're anthropologists. This is our method. Obviously, we're going to, you know, check these kind of things as part of doing our research. It goes without saying. But so that allowed me to refine my argument a little. What I'm saying is that those things are rendered invisible sometimes in the output, and the material that sits alongside that output even. And that is damaging to the long-term dealing with that group or that matter, especially when you have junior anthropologists coming through working on that material for the first time, and they may not have experience with that process of compiling that expert evidence, and they may take it at face value and think, well, that's all there is, that's the final position, that's what I go off, and they may take that as, oh, there is no value in me doing this broader, more comprehensive methodological process that the consultant may have done. They may have done their due diligence and done a really solid job, but if that is not effectively conveyed to the anthropologist, you know, picking it up next, then there can be issues in misinterpreting things or missing things that might have not have been relevant at the time, but might become relevant later. So that's where I'm really keen on documentation of these kind of things all along the way. And that's on the anthropologists and that's on whoever's preparing that, but it's also, I think, helpful to lawyers to be mindful of that in their involvement in those early stages of collecting data. Up next, I just thought I'd put these definitions up. Just these are concepts that are easily confused by people not familiar with the subject matter. Apical ancestors is pretty straightforward, but it does have the nuance in the Native Title Act of we're specifically usually referring to people who are there in the claim area at effective sovereignty, whereas if you weren't working in native title, you might have a more general meaning of just whoever the earliest people are, regardless of when they lived. So it has a more defined, more refined and restricted meaning in the Native Title Act. Descent and filiation are somewhat confusing to differentiate sometimes, and people conflate these, and both of these things are shown on genealogies quite often. And so hopefully my definitions I've had a crack at make sense up there. So descent is when you're showing sort of a line. You're showing connection to between person down here and ancestor up there. And you need to show the links along the way to show that path of descent. Filiation is more focused in on the individual linkages along the way and how those linkages operate. So that's where you have a system of, and it's also often can be differentiated between what people say to you, how people explain and articulate their system of recruitment to a group, compared to how we might abstractly deal with it after the fact in our analysis. Now, the existence of the Native Title Act has kind of changed these processes somewhat, but in a lot of the earlier materials, Aboriginal people didn't have a lot of genealogical depth to their knowledge of their family, and they didn't necessarily talk about their distant ancestor as being the basis of their rights. They would speak more about their father or their father's father, and that would be what they would focus in on. But then through the collection of further evidence, the lawyers will compile an argument, as they need to under the Native Title Act, that there is this descent as well from this named ancestor that the claimants may or may not actually remember. So that's where that differentiation becomes quite important to understand, and because you can draw attention to either of those things or both of those things using genealogies. Now, how am I going for time? I've got a couple of case studies I wanted to just talk through quickly, and then I'll just open up to questions. I'll try not to talk for too long about these or go into too much depth, because I could spend a whole day on each of these things, I'm sure. But just to flag some of the issues that I've encountered. So this one, both of these are from the Northern Territory at the Northern Land Council, and I've anonymised the names that I'm going to put up and everything. So this is a case of the same people, the same families coming up in different claims. And so their genealogies get redone in different contexts, and they don't look the same in every claim, and the group structures are presented slightly differently. And in each case, that led to a successful claim, and these people got their rights granted in association with those claims. And since those claims, though, the Northern Land Council continues to work with them in administering their rights, making sure their rights are respected. And in the course of that, various tensions and disputes tend to arise sometimes, and there are sometimes confusions that arise because of referring back to that older evidence that doesn't always match up or doesn't always paint a clear picture. So in this case, there was a 1980 land claim under the Land Rights Act in the Northern Territory, which had quite a broad group. And then in 2013, there were two separate native title claims where the group was presented as three separate groups, actually. So I'll just show you what the genealogies look like. So this is the form of the 1980 land claim genealogy. So I'll draw your attention to these two brothers here, presented as full brothers, under the father being the apical ancestor. These were all part of the same estate, which was of the Guyal semi-moiety. And this is probably like the Gulf of Carpentaria region of the Northern Territory that I'm looking at. Now, the person I've coloured in black is one of the key players in this dispute between two individuals that I'm talking about. So she came in here on the land claim genealogy. Then the first of the native title claims is a smaller group, subgroup of that wider group. So this is just one of those brothers is presented as the apical ancestor here. And so you've only got this one line of descent. You've still got that same lady is showing up here in this native title claim. Now, the other native title claim was the other brother. Now, this brother didn't have any biological children, so it was necessary for him to incorporate new people under him for this group to carry on. And this is where that lady from before, from the other line, was brought in here. And you've also got another gentleman brought in here, and his son was the other person in dispute. And they were in dispute about who should be in authority for this newly constructed group from this 2013 native title claim. And he was arguing, well, my father was grown up by this man. I know that country better. I should be in charge. And this lady was explaining her incorporation of the group as through conception and discussion between her biological father and other people involved with this group to give her that authority to come into this group. And there was also an argument about skin names that became relevant as well. I won't go into depth there. Now, to untangle this, I didn't have all this broad context initially when this came across my desk, and I needed to understand what was going on. So part of what I did to understand this was I did a new genealogy, and I updated the old land claim genealogy and mapped it out more comprehensively than it was ever in the claim process using the data that we had from different reports. And this is quite confusing at first glance. I don't expect anyone to quickly understand this, just as demonstration, really. But this one included the gentleman over here and the lady over here, and it showed, although this father was adopted, he did have an affinal relationship to this gentleman here. So you could see more clearly the relationship between these two people. And this is a relationship that is very clear to these people themselves. They know who they are and how they're related to each other, and they know that they're family. So it's not news to them, but it helped me as the researcher to really understand that context before I had further conversations with them. And this is something that wasn't evident in the claim materials, but I had to kind of go digging and cross-referencing the basis of these opinions that were presented in these genealogies. So I put this together and I did a bit of analysis of, what skin names do people have? Why is that the case? How are these people related to each other? What other groups play into this? Why was the group split into these three different groups rather than the one overarching group? And this was all made possible through genealogical methods that I came to this understanding. And this didn't necessarily quickly resolve the dispute, but it gave us a starting point for how to proceed from there. So that's where the genealogy method was quite useful in that case. Now, my other case study here is more about an urban setting, a cognatic group. This is in the NLC's Darwin-Daly region, so it's sort of a more settled area of the Northern Territory that I'm going to talk about. So Peter Sutton, in his book on native title, which I'm sure most people here are familiar with, he talks about what he calls families of polity, to come to grips with cognatic family groups and how they fit into the definitions of native title, as being more than just family, but actually being a descent group that meets the legal criteria required. And he talks about how they're formed out of a reaction to colonisation that, disrupts what was already going on there, what continues out of that context, and usually those things that carry on, even in the most disrupted areas, are ties of family and kinship and responsibilities that people have to one another in a family sense. Those things tend to be used in the reconstruction of descent group structures later on. And we get to points where you have surname family groups being sort of subgroups within this wider group some of the time. So if anyone hasn't read Sutton's material on that, I think it's kind of required reading if you're going to be working in this space, particularly as even in more remote areas, we're seeing group structures like this come up more and more over time. Now, in the case that I'm thinking of, I don't have genealogies up here for this one, but I just thought I'd give you a sketch. The case I'm thinking of, there are 3 different families, really, that come into this one language group, cognatic group, that is presented in claims as a descent group. Now, the first family, there's a few different branches. Now, one branch of that family, this is their only ties to land anywhere. This is the only thing that they've got a stake in the game is to get their rights recognised through this language group. If they don't get recognised as part of this group, they've got nothing. They're not recognised as TOs anywhere. Now, the second sub-branch of this family, they have actually got ties to another group somewhere else, and they've pushed away, they've cut off their ties to this group. They're not interested, they've got their rights somewhere else, and those are where their primary interests lie, and they have nothing to do with this. There's a third family who have other options available, and they've kind of done both a little bit. They have some rights with this group, some rights with another group, and they go back and forth, and this is closely tied to the politics of the groups. Now, the second discrete family were brought in from a different area, or some might say brought back in. That's a big question that I'm not going to get into because it requires all the details. But they were not in the statutorily recognised group initially, and they later on joined the group, essentially. And then the last family, they also, like family 1B there, had some other options available through cognatic ties to another group elsewhere. So Now, the issue is that, like, again, in the post-claim environment, these structures can sometimes fall apart a little bit or lead to a lot of disputes when there's different parts of the overall group that we've established is a cohesive descent group. But once you poke and prod at them and get them to, fit themselves into this legal framework where they have to actuate their rights in terms of, consenting to developments or determining royalty payments or planning what to do with their country. These different motivations and contexts that they each come from can come into play. So I guess as just a bit of an open-ended question is sort of what responsibility do research and legal staff bear in relation to this side of things when claims are being put together? Because there's a risk that these kind of effects can be neglected in the course of doing a claim because the lawyer's focus is on getting the claim done and successful and getting rights granted, but not necessarily always considering what comes next for these people and what's in their best interests as a community, as a descent group, as native title holders. And then what can we do about it, though? I don't really have an answer to that, and I think it's a longer topic, but I'm just flagging it as something that I think lawyers should have in mind when you're starting to work on these things, especially in groups that are very complicated in how they're put together and who may not be familiar with the legislative framework that they're henceforth going to be very intimately involved with. They may never have been before. All right, so I think I've made good time, so we've got time for a little bit of discussion. So I'm going to go back to my initial question that I put to the room. Have you ever drawn a genealogy? What did you include? What didn't you include? And why? So this question is for anthropologists in the room. If anybody would like to put their hands up and give me an example of a genealogy you made, and maybe if you had to make any decisions about what to leave on or leave off, besides just descent. If anybody has any examples that come to mind or any comments on that scenario?
Yes.
Yep.
Well, sometimes there might be multiple relationships with one individual, so you might need to say number one wife, number two, whatever, that sort of thing. Sorry, I was just going to say that sometimes people have more than one spouse or partner, and you need to be able to number those in sequence. And then, of course, numbering the descendants of particular parenting in sequence is also can be tricky when you're just taking it down to get the order right.
No, I agree.
Must be somebody else.
Anyone else?
Just a quick comment. Thanks for the presentation. One of the issues with genealogies, and I think this is more for the lawyers than for us anthros, is this apical ancestor. There's a catastrophic movement amongst the courts to define groups in terms of cognatic descent of an individual. And it's what I call a governance catastrophe in the making, because by definition, each group has more and more width and more connections to other places. We need to find ways of tracing descent to particular areas in our genealogies, not leave it open to the lawyers and the courts to do the apical ancestor thing. As I say, catastrophic.
Yeah, and that ties to, I think, what I was talking about with collecting broader data at the time of doing the research, particularly in terms of things like decision making and cultural authority of particular parts of the group and how those things function that are not directly relevant to whether the group exists and whether they have native title, but are critical to the functioning of that group on an ongoing basis. And anthropologists are often very involved in that side of things after the claim, after the determination as well, especially at big rep bodies like the NLC, where you've got a huge area of land and most of it is Aboriginal land. And most of our work these days is not claim work, it's dealing with the administration of people's rights under the Land Rights Act, and being equipped with sufficient data to make the call on who has decision-making authority and how those things are decided in the group is really critical, because we don't always have the resources and the time to go out and do as much new ethnography as we would like to understand those kinds of things. So I think putting that into the court process would be very helpful.
Well, sorry, even perhaps before the claim is filed, I mean, all those matters you talked about.
Microphone.
I can't help it, I just love talking so much. I think all those matters you mentioned actually do come down to the traditional law and custom, which is what native title is all about, and really should go into formulating, I guess, and I'm sorry to use the word formulation, that probably is not a good anthropological term, but the claim group description. I think we've just been working on a matter where it seems like there is a formula that's used in all the Form 1s that people sort of potentially cut and copy without much thought into whether that really reflects the group's traditional law and custom. And what we're trying to do is do a lot more of that work in the what we call regional research phase before we even get to the filing of a claim. But it does mean a lot that the resourcing into that part of the work needs to be there, and it's hard when you're also juggling court matters and things like that. So, but I do think that what you're talking about does come down to the group's traditional law and custom, and lawyers have a obligation to try and work with the anthropologist to understand that before we even get anywhere near a Form 1.
Yeah, I think sometimes what we're dealing with is a somewhat incomplete account of the law and custom, and that causes problems. Even if it gets through the courts, and even if the judge is happy with it, it may not be complete in the sense that I think it should be. Yeah. Anyone else?
Yeah, thanks for the presentation. Look, this is a really pressing problem. Sometimes claims, particularly in places like Victoria, can take 15, 16 years. And what the claim group looks like in the first year is often not what the claim group looks like in the last year. And there could be different iterations of research done during all of those years, and indeed different iterations of the claim. The boundaries can move, the applicants can change, a lot of things can change. And going back to what David was saying, and you were saying, with the emergence of sort of focal ancestors sitting under apical ancestors and surname descent, surname groups, they often become kind of political factions within a claim after a while. And you can have instances where two surname groups clearly descended of the same ancestors are diametrically opposed to each other and challenging their authority. So I'm not saying I know how to fix this, I'm just saying this is a definite problem when we focus on apical ancestors. And the other part to that is we focus on apical ancestors a lot because under an ILUA we're asked to include all the people who hold or may hold native title rights and interests. So it's kind of a system that's set up to create these conflicts, and we really need to put much more effort into understanding that there will be conflicts and understanding what those conflicts will be, and arming the people who will be involved with those conflicts with some kind of way to navigate a complex modern legal system and a complex traditional system of law and custom, or normative practices with their footprint in that older, set of laws and customs.
Yeah. Thanks. I'll move on to my question specifically to call on lawyers now. I'm keen to hear from as many lawyers as possible in the room what you've made of the presentation and what might be new to you, or what is a problem that you encounter with working with genealogies. Any lawyers specifically got anything else to add? Yep.
Thank you.
I just had a question about when you were collating those three genealogies. Did you find any discrepancies between the three of them, and how do you reconcile differences?
Yeah, I
in
found them
information?
pretty consistent in terms of like the information that was represented in each one was actually consistent. So she had the same number of siblings. Her mum had the same number of siblings. They were same gender. So in that sense, it was consistent. So that kind of gave me a little confidence of like, oh, okay, she does kind of get what this is. She's not just drawing random symbols. But yeah, I didn't do any further digging into the bigger final version, whether or not that was correct and whether she would reproduce that again if asked to. Yeah.
You've never experienced discrepancies in doing that task before? Like, how do you, if there's a difference saying, you know, in this genealogy, this person is related to X, but in this one, they're not.
Yeah, and that is something that I've encountered plenty, though, working with Aboriginal people in native title and land rights matters. You get, even with the same person on different dates, they'll draw their genealogy a bit differently. And sometimes it depends on the context and what they're talking about. The other big difference we often see is whether or not people were biological siblings, or if they were classificatory siblings, or if they had some ceremonial relationship. Whether it's any of those things, in certain contexts, they will present them as biological siblings on the genealogy or in the way that they explain it to you. So there is sort of a level of analysis that needs to go on there. Once you encounter those inconsistencies, it may not be an issue. It may not actually be significant to the nature of those relationships as they're lived in that community. But the inconsistency is there on paper, and so you need to be able to explain it and explain to a lawyer, explain to a judge why that inconsistency doesn't discount the evidence. So that is part of the research process, certainly.
In our region, we're plagued with Norman Tyndale genealogies. What weight should a lawyer put on a genealogical chart drawn by Norman Tyndale?
Yeah, possibly not as much as they sometimes do. Although I found the ones that I've worked with, the actual relationships between people have usually been pretty spot on. That may not be universal, but in terms of his tribal categories and things and where people are from, that's where the issues tend to arise.
The shorthand he uses is another whole issue.
I find them quite hard
and
to
I'm
read.
sure there's a PhD in it for someone.
Yeah.
But the problem with them is, for us, they become gospel to our constituents.
Yeah. I encountered claimants, they get their hands on a particular document, and it might be, quite often it's Tyndale's genealogies, or it might be some other report that was done a long time ago, and that report or genealogy may have issues with it, and it may have since been replaced by an alternative version as this sort of accepted standard, but the claimant might cling to that older form of the data, especially if it helps their case, and that can be a very difficult thing to work through with people as well. And I don't think I have any silver bullet for fixing that issue. I suppose transparency is helpful, perhaps, in talking through people about these things early on. It's kind of a risk sometimes because you might get people offside and you might end up arguing with people when you don't want to be arguing with them. But I find people get really standoffish if they feel that you're hiding things from them, or they feel you're being deceptive and you're not. You know, they feel like, oh, this guy was on my side and he was listening to me talk about this, but then in his report he said something completely different, and why did he do that to me? Even if you do in a way that ultimately leads to the case being successful or helping them. And I mean, the case that always comes to mind to me for this is the Finnis River land claim in the Northern Territory with Peter Sutton's involvement there. I think it's a lot of people here have probably looked at that case before, but there was a case of succession where the claimants didn't want to argue succession. They felt it was always their country. Peter Sutton took a different view. He thought it was a case of succession, and he argued that that was his opinion. And based on Sutton's opinion, those people got granted rights to land. And so they were granted rights to land on the basis of something that they didn't agree with. And there was a lot of feelings of betrayal and distrust arising out of that scenario, that the effects of which are ongoing to this day. So that's something that needs to be given thought in how we interact with people that we're talking to about claims.
So to speak to what you've just spoken about, going back to that real life example, if we could, where you had the adoption but you also had a matrilineal or a mother's line, how did you reconcile the dispute between there was one, I think, an auntie, the adoptee, but also the fellow who had that, if you go back to the other... the larger one, you can see where she comes from, that other side. And this fellow over here, Matthew, if you can explain how you, through the analysis of the new information that came to light, how was that reconciled with your interlocutors?
It helped me have a conversation with the gentleman. I didn't directly talk to the lady at the time, but my initial conversation was with the gentleman who was calling me up complaining about this. And so once I went away and researched this and understood it better, I had another chat with him. And I talked through with him the logic of why the claims may have been put forth the way they were, because he didn't know that at all. He'd never seen the native title claim genealogy from which he got granted his native title rights, which in itself is an issue, I think, that he'd never seen that genealogy before. But I showed it to him and I talked him through it, and because the first time he saw it, he was like, why is she on there? She doesn't belong on there. And so I was able to give him an answer to that question. Even though I didn't resolve the dispute, I was able to explain to him, okay, through my research into what went on in this claim and how it was put together, even though this wasn't documented in the report, that this was like a new way of structuring this group, contrary to how it had been done before, and why they did it that way. I had to quite dig to figure that out. But I was able to explain that to him and talk about at what point she was involved in the claim and how he was involved in the claim and how that came together. And I mean, as I said, he was no stranger to the fact that he had this kinship ties to this lady. That wasn't new information to him. But just to reassure him that we knew that and we understood that, and that's how it was incorporated into this process, I think that did help him at least understand the issue. He still had the issue that he disagreed with conception being a basis for taking rights to country. And he felt that his father, having been grown up on that country, was more significant. And that was kind of an agree to disagree thing that those two people probably still dealing with. I didn't see a resolution to that. But I hope that equipping them with the understanding of the claim process and the logic that went into that will at least help in some way.
Probably more just a comment than anything, but just on our responsibility as rep bodies to be working with claimants more in the claim phase about teasing out their law and custom in terms of adoption. We've recently just had a claim proceed to a consent determination, and the state was pretty firm that adoption had to be included specifically in the claim group description, and now we have a situation where the PBC doesn't know how to apply the rule of adoption and what they classify to be, the Western form of adoption versus rearing up. And we've had quite a few issues now where people that are stepchildren are applying and people don't know whether that really fits within the rule. So probably just more, a comment on our responsibility early on to be working that out rather than leaving it now where we've got all of these unresolved membership applications that no one knows what to do with.
Yeah, I think you want to steer away from like sort of blanket statements and very general descriptions of that kind of thing that does leave you open to just whoever has, a certificate that says they're adopted, then therefore they're automatically in the group. Unless that's what you've been instructed specifically and the claimant group is on board with it being done that way. But I think a lot of the time though, there are, cultural processes in law and custom to differentiate different kinds of adoption and what that term means and any other things besides adoption that can bring someone into the group. An anthropologist is well trained to tease out those different things if they're asked to do so. If all that gets put in, they may do so in the field. They may have that in their field notes or in their head. But what gets put into the Form 1 or into all the documentation might end up being a pretty general statement just to squeeze it in there to satisfy somebody. And then at the end of the day, when you're trying to work it out, that's the thing that you go back to. And it might not be practical to contact the anthropologist, or it might not be possible to do further research, or to access field notes and that kind of thing. And so it's important to have sort of an idea in place. Okay, if we're going to abridge this for some administrative purpose that needs to be done to get it across the line or whatever, if you have additional context already, don't chuck it out. Don't be careless about what's done with that. It needs to be retained and accessible in some way, because it can be like the one thing that is a silver bullet sometimes if you have that qualification and clarification from elders who have passed away about how they wanted it to be done. And if it's somebody that was respected by all the disputing parties, they may say, oh, okay, then we'll follow what that person said so that we don't have to decide, we don't have to agree about something either of us have come up with. That's just what we do. And that's where having really solid methodologies of research in the genealogical compilation phase is really critical, and you're not just sending out a new staff member or a lawyer to compile a genealogy based on what they think a genealogy should be, without being someone who has the training and experience to properly do an anthropologist's genealogy that the lawyers can then determine what to do with from there.
This is probably a slightly more macro point than just about genealogies, but something that we've been doing at NTSG, and I say we in the broader sense, I've had nothing to do with any of the projects that are doing this, so I'm probably going to point at Trinity over there, who has been more involved, but is, we've identified that there are these issues with, say, the Form 1 or the determination is framed in a particular way, and then you have these disputes within PBCs after the fact. So actually front-loading a lot of that work about addressing those issues, even in the research stage before we've drafted a Form 1, working with groups on, okay, you're going to be the group for this area, that's fine in terms of the list of apicals that goes in the Form 1, but how's your PBC going to work? And how are you going to make decisions about land? And how are you going to deal with people who are adopted and want to be members of your PBC? So yeah, sort of doing that consultation work right through the research phase, with the idea being that at the point in time, and please shake your head, Trin, if I'm wrong about this, the point in time at which we've drafted a Form 1 and file it, we've actually already pretty much drafted a PBC rulebook as well.
Yeah, I think that's a good way to go about it if you can. I suppose the issue is when you don't have the resources to do that, what do you do? And that's the issue that I've come up against many times when I'm calling for a particular way of approaching something, and it's like, well, yeah, but we don't have funds to get a consultant to go and do that. Or everybody's overworked and we've got all these other projects on the run and we've got to send everyone over here and over here and over here. This one has enough to get across the line, so we're not going to invest that extra thing, even though we think it needs it. I'm at a bit of a loss, I suppose, as to what to do there, but that's something that we all need to think about whenever we can.
You talked about how to include people on genealogy and a claim and a claim group description. When we start on a project as an anthropologist, you are given often a Form 1, which is very simple, and it's a list of apical ancestors and just mentions descent. And as David said, that's sort of catastrophic long term because everyone can be included. What needs to be included, I think, is how do people drop off the claim or the group? So that you might mention things like those other affiliations might mean that they no longer belong to the group. Or it could be like participation in the social economic life of the group. If they've formed connections elsewhere or activated connections elsewhere, maybe they're not members of the group, but the claim group descriptions don't seem to allow for that at the beginning. And then when you write the report and you make those sort of nuanced arguments, it's very difficult for lawyers to construct a PBC rules around that.
Yeah.
It's just a comment.
Yeah. And related, similar, like, common problem I've encountered is in situations where there's a family line through adoption or through the depletion of the group, a person through their mother is brought in or something like that. There needs to be clarity about the next generations after that, because sometimes it's very clear that a particular person has been incorporated into the group, but then when their children come later and they weren't on the original genealogy, they weren't mentioned in the report, maybe that person didn't have kids at the time, their kids are saying, well, my dad was adopted into this group, so I should be part of this group. Sometimes that's the case and sometimes it's not. But that's something that I haven't commonly encountered being spelled out or researched deliberately in the reporting that was done that is the basis for that adoption principle being accepted. So we've had to do further follow-up research to try and tease that out, and sometimes it's quite impossible to work out what things how it would have been put to you 20, 30 years ago if you would ask these questions. People might have different views today, but you're expected to tell them how it was back then.
Thanks. I think I have a comment more than a question, which is to suggest that we need to think about the role that the state plays as respondent parties in the simplification of connections to be reduced to apical ancestor names and cognatic descent, because they have the capacity to withhold giving consent, and everybody's motivated to get the thing done. And their motivation is, well, I don't want to be too specific, but I think a large part of it is to render legible traditional owners so that there's somebody that they can determine who it is that they need to deal with in future dealings. And I think they see reducing Aboriginal kinship to something equivalent to whitefella kinship allows them to do that.
Yeah. All right, I think that's about it. So thanks for having me, everyone. Oh, it's lunchtime, everyone. There's food. Enjoy. Till 1:30? All right, 1:30, we're back.